Hello and welcome to Forbes Let's Talk Employment Edition podcast. I'm Catherine Hare and I'm joined by Jennifer Smith, who is partner and head of commercial employment law at Forbes Solicitors. So today we're going to be looking at the new Employment Rights Bill. So Jen, what's the background to the bill? Has this emerged due to a change in government?
Well, firstly, hello, Catherine Hare. It's great to join you today.
Hello.
With regards to the Employment Rights Bill, when Labour won the general election this year, they promised wholesale employment law reforms and committed to lay before Parliament an Employment Rights Bill. And they committed to do that within 100 days of them coming into office. Now, this seemed like an extremely tight timescale for such all-encompassing changes. However, to be fair to the government, they have met their commitment. And on the 10th of October, the Employment Rights Bill was published. In the press release accompanying the bill, the Department for Business and Trade described the reforms which the bill introduces as landmark reforms, which will help to deliver, quote, economic security and growth to businesses, workers and communities across the UK.
Wow. So some really strong commitments there from the Labour government. So are these changes to employment law going to be imminent, do you know?
There's a lot of scaremongering that's happening in the press. Nothing is likely to be imminent, certainly not the chunkier stuff, so to speak. First of all, it is worth noting that not all of the reforms which Labour propose to make require primary legislation. Some of the changes will take place via codes of practice or change to the remit of existing bodies such as the Low Pay Commission. There also isn't a set date when the employment law reforms will take place. The bill itself will need to go through the parliamentary process where it will be scrutinised by MPs and peers, which may result in amendments being made to the original proposals. In an accompanying next steps document to the Make Work Pay document that the government released, the government confirmed that reforms regarding the right to claim unfair dismissal, for example, will take effect no sooner than August 2026. So almost 2 years away. The government have already launched consultations on some of the provisions contained in the Employment Rights Bill. The consultations will request views in relation to the new right to a guaranteed hours contract for zero or low hour workers, collective redundancy consultation, and fire and rehire practices, reforms to the trade union legislation and statutory sick pay. We'll keep a close eye on the outcome of these consultations, which will run into early December 2024. That much we do know. So therefore, it appears that employment law changes will be piecemeal. So organisations, they will need to keep appraised of the ever-evolving employment law landscape, but I wouldn't be expecting anything to happen overnight.
Great. Thanks, Jen. Certainly lots going on and lots for business owners to keep appraised of. So what are the key takeaways from the Employment Rights Bill?
I'll be asking me key takeaways, Catherine Hare, on a 158-page document.
I'm challenging you.
So, well, despite the fact that the Employment Rights Bill is 158 pages in length, it is actually quite light on detail. So we therefore will need to see what emerges as the bill passes through the parliamentary process and we see the outcome of the consultations, which I've just mentioned, which the government proposed to implement. As the bill is quite lengthy, though, I'll try to focus on what I take as being the 4 or 5 key points and talk you through those key points.
Great. Thanks, Jen. I mean, first of all, there has been so much commentary about the right to claim unfair dismissal becoming a day one right. So what do we know about this?
Okay, so lots of commentary in the news about this. In my opinion, this is probably the biggest change that we're going to see. So the 2-year qualifying period needed to bring a claim for ordinary unfair dismissal will be removed. So that will become a day one right. And as we said though in the introduction, the government have confirmed that this reform will take effect no sooner than autumn 2026. So it's still a long way from now. However, alongside the creation of this day one right, there is a caveat to this. Where a dismissal takes place during an initial period of employment and is for the reason of capability, conduct, statutory contravention or some other substantial reason, SOSR as we call it, which sets out when a dismissal may be fair, can be modified. Effectively, this means that the bill will allow businesses, employers, to operate probationary periods during which there will be a lighter touch process for employers to follow to dismiss an employee who is just not right for the role. It does not appear that this option will be available for a dismissal for the reason of redundancy, but it is worth noting that the bill makes it clear that the right to claim unfair dismissal will not ordinarily apply to employees who are yet to start work.
Mm.
According to media reports, the government's preference is for the initial period of employment, or a probation period, as you and I refer to be 9 months. However, there will be extensive consultation on that point, and no doubt there will be a lot of healthy tension, I would imagine, in Parliament when they are discussing this. I think what's important to note is that the length of the qualifying period to claim unfair dismissal is something which has changed over the years, fluctuating from 6 months to the 2 years we have at present. So this concept isn't something brand new, if you like. It has been changing and evolving since the 1970s. What it does mean, though, is that it's really important as business leaders to ensure that your recruitment purposes are fit for purpose and aren't the informal chat which may have taken place previously. In addition, it would be sensible to think about your probation periods, consider how these are monitored, and if you have the robust procedures in place to ensure that new recruits are a right fit for your business. I think these changes may also mean that some organisations need to think about their business model and may look at using more agency staff, perhaps, or seasonal workers. We're having dialogue already with businesses, and one of our manufacturing businesses has said very clearly, I'm just going to probably use more agency staff now. So it'll be interesting to see how businesses evolve now over the course of the next couple of years. Continuing on the theme of dismissals, there will be a ban on dismissing an individual when they return from maternity leave, which we anticipate will mirror the current redundancy protections. Okay, so currently what's in place, we think it is going to mirror what is in place in the redundancy protections and perspective for those individuals who are returning to work from maternity leave. Finally, we were led to believe that the Labour government would introduce an outright ban on fire and rehire and fire and replace. However, this isn't the case. Instead, employees will be regarded as having been automatically unfairly dismissed, either if they are dismissed because the employer sought to vary the employee's contract for employment and the employee did not agree to the variation, or to enable the employer to recruit another person or rehire the employee under new terms, but with substantially the same duties. However, there is now an exception if an employer can show that the reason for the variation was to eliminate, prevent, or significantly reduce or significantly mitigate the effect of, and I quote now, any financial difficulties which at the time of the dismissal were affecting or were likely in the immediate future to affect the employer's ability to carry on the business as a going concern. And in all the circumstances, the employer could not reasonably have avoided the need to make the variation. If any of these reasons are cited by an employer, matters that must be considered in determining the question whether the dismissal is fair or unfair include if any consultation is being carried out by the employer with the employee about varying the employee's contract. Also, if the employer carried out consultation with a recognised trade union or employees who had authority to be consulted on about the dismissal. And if there was anything offered to the employee by the employer in return for agreeing to the variation. So this is a really high bar for businesses, and I think that it will be a question of economic survival to meet this exception, but it certainly isn't an outright ban.
Thanks, Jen. Yes, we did think that fire and rehire would be an outright ban, but it turns out that there is this exception. And turning to flexible working, we were led to believe that in the press, especially, that everyone would be able to request a 4-day working week and that an employer would need to accommodate this unless it wasn't reasonably feasible. So is that the case that flexible working is now the default?
So we did see lots of scaremongering in particular.
We did.
Lots of headlines, both on the right side of the media as well as the left side. The Guardian in particular had a headline about this that would quite rightly so put fear into the minds of employers. The right to request flexible working is already a day one right, but it was thought that the Employment Rights Bill would provide a wholesale change to flexible working, where this would become the default unless it was not reasonably feasible to accommodate the request.
Yeah.
It's not been that. Instead, the Employment Rights Bill references there still being set grounds for rejecting a flexible working request, which are similar to those currently in place. So ignore the headlines. There is an additional requirement for an employer to explain why they consider that it is reasonable to refuse an application on that ground or those grounds. And there may be a requirement to consult with the worker before rejecting a request. But these are quite minor changes, and it certainly isn't the huge change to flexible working that was anticipated. So please be reassured by that.
Thanks, Jen. And I think the obligations that the Employment Rights Bill are suggesting that you take are what a prudent employer would do in any event if they were thinking about rejecting a request. So, yeah, that's really good to clarify. And I know turning to sick pay, that's something that is something that's a concern for businesses if they have high levels of sickness absence. We did think there were going to be changes to statutory sick pay. When people were talking about day one rights. So what's included in the Employment Rights Bill with regards to statutory sick pay, Jen?
Yes, so this is one that lots of employers are understandably wanting to take note of. It still is a real pain point for lots of businesses, sickness absence. Now, the waiting days prior to SSP being payable for those entitled mean that SSP is currently only available from the 4th day of sickness. The bill, the Employment Rights Bill, proposes that these waiting days are to be removed in their entirety, and statutory sick pay, SSP, will instead be payable from day one. In addition, the lower earnings limit that was applied when looking at eligibility for SSP will be removed. However, it is worth noting the Employment Rights Bill just set out a lower level of sick pay for lower earners. I think in reality, what will happen with SSP is that the rate of SSP will be increased. It is actually quite low cap compared to other European countries.
It is.
We just need to watch this space, basically, with regards to reform. As I have said earlier, there has already been a consultation launched regarding these proposed changes to SSP. And I think it is recognised by the government that this could have a huge impact on businesses. So they are consulting on it.
Yes, I think the consultations is going to end at the beginning of December, so it isn't a long period for consultation. So the government really are moving quite quickly on this. So we will of course keep everyone appraised of developments. So we did expect the Employment Rights Bill to include significant trade union reforms. Has that materialised, Jen?
Yes, that definitely has. So, contained in the Employment Rights Bill, there are significant provisions which propose to strengthen the rights of trade unions. I don't think anyone was really surprised by that. Angela Rayner's background is very much in the trade union heartland. So I don't really think we were too surprised that they delivered on this manifesto promise. The bill repeals what Labour have referred to as the current anti-strike legislation, including that which provided for minimum service levels during a strike in a relevant service. In addition, the Employment Rights Bill includes an obligation on employers to give a worker a written statement that the worker has a right to join a trade union, which must be given to the worker in their Section 1 statement. Okay, so it's almost like it's being advertised to the employee, and they're being told they have that right. Also, the introduction of access agreements, which will be an agreement between a listed trade union and employer that provides for access to a workplace by one or more officials of the union for any of the access purposes. The access purposes are to meet, represent, recruit, or organise workers, whether or not they are a member of a trade union, and to facilitate collective bargaining. The access purposes do not include organising industrial action, though. Employers will be under a duty to take reasonable steps to facilitate access and will only be permitted to refuse access entirely where it is reasonable in the circumstances to do so. Now, what amounts as reasonable, we have yet to find out. The Central Arbitration Committee will determine any subsequent disputes
Mm.
as well. So there's some big changes coming. There's also going to be a change in the percentage required for recognition of a trade union, where the Secretary of State will have the power to lower the threshold for compulsory trade union recognition applications. The requirement for a recognition ballot to have a turnout of at least 40% of the relevant bargaining unit to be valid will be removed. And the ballot requirements for industrial action will be changed to a simple majority. And finally, the existing time off for trade union activities will be extended to incorporate equality representatives for recognised trade unions. There will also be a requirement for employers to provide representative with accommodation and other facilities for carrying out the duties or undergoing the training for which the employee is taking time off. It must be reasonable in the circumstances. What amounts to reasonable, though, we've still yet to see.
Yeah, thanks, Jen. I think we're going to have to wait and see on a lot of this, aren't we? Um, so finally, there was also a great deal of press coverage around this concept of an employee's right to switch off. So is this included in the Employment Rights Bill?
No, it wasn't. So it
Okay.
wasn't included in the Employment Rights Bill. We were all looking out for it in the
Mm-hmm.
108 pages, but no, it wasn't there. What was included in the next steps document, though, where there will be a call for evidence on this prior to a code of practice being introduced. So we still expect there to be commentary about this. What we do think is we expect that we may end up in a situation similar to what they have currently in Ireland, where there is a general expectation that employees disconnect from work emails and communications outside of normal working hours, but with built-in exceptions such as where business and operational needs dictate that an immediate response is required. So it's quite useful to look at what currently is happening in Ireland. There's a few European countries that currently have this in place, but no, it wasn't included in the Employment Rights Bill. So there's nothing really we can talk about in any detail about this. But if people want to have a look at how other countries are dealing with it, I would certainly reference you to Ireland, and they've got a code of practice there, and also have a look at Belgium, Portugal, I think, is it, Kat?
Yes, Portugal. Yes,
Yeah,
yes, and some countries do impose financial penalties. That's not the case in Ireland, I'm led to believe. So it may be more of a lighter touch approach
yeah.
compared to other countries. So we'll have to wait and see on that as well. Oh,
Thanks.
thanks so much, Jen. That's been brilliant. You've accepted the challenge and met it with a plum. So this has been a whistle-stop tour of some of the key provisions contained in the Employment Rights Bill. We shall, of course, keep you all updated with the developments as and when they occur. I think it'll be really interesting to observe the tightrope, I think, that the new government are going to have to walk to ensure they deliver on their commitment to be both pro-worker and pro-business. That's certainly a challenge for them. But thank you for listening, and we look forward to the next podcast in the series.
Thanks, Kat.
Thanks, bye.